This is Samsak, and in this video we are looking at non-fatal offences against a person. So there are 5 main non-fatal offences against a person, which include assault, battery, assault occasioning actual bodily harm, maliciously wounding or inflicting grievous bodily harm, and wounding or causing grievous bodily harm with intent. Now, assault and battery, the least serious of the 5 offences, are summary-only offences, and they're charged under Section 39 of the Criminal Justice Act 1988. Now, they carry a maximum sentence of 6 months imprisonment and/or a fine. Assault occasioning actual bodily harm and maliciously wounding or inflicting grievous bodily harm are more serious and either way offences, and they're charged under Sections 47 and 20 of the Offences Against the Person Act 1861. So these offences carry a maximum of 5 years imprisonment. Now, the final offence of wounding or causing grievous bodily harm with intent is the most serious of these offences and is an indictable only offence charged under Section 18 of the Offences Against the Person Act 1861, and this offence carries a maximum sentence of life imprisonment. So first of all, we will look at assault. As assault is charged contrary to Section 39 of the Criminal Justice Act 1988, and in DPP and Little 1992, the Divisional Court held that assault and battery are statutory offences. However, in Hasted and Chief Constable of Derbyshire 2000, the Divisional Court held obiter that battery was a common law offence, and in Fagan and Commissioner of Police of the Metropolis, James J. defined assault as any act which intentionally or recklessly causes another person to apprehend immediate and unlawful personal violence. So we'll now look at that and what each of those words mean in context. So the first one is apprehension. As if the victim does not apprehend immediate personal violence, there is no assault. So consequently, raising a fist to the back of a victim's head where the victim does not see the threatening gesture would not constitute an assault. The victim must also have heard any threatening words that were said and apprehend some personal violence. Now, there does not need to be any physical violence. For example, in Logden and DPP 1976, the defendant committed an assault when he opened a drawer to show the victim a replica pistol, and the victim feared that unlawful force was about to be inflicted upon him. Now, although it is often present, fear is also not a necessary requirement of an assault, and instead there must only be the actus reus of the assault and the anticipation of unlawful violence. So the anticipated personal violence must also be unlawful, and the conduct of the defendant might be deemed lawful for a number of reasons, including if the defendant is acting in self-defense or the defense of another, if the conduct is consented to, which we'll talk about later, if the defendant is using a reasonable amount of force in the chastisement of a child, and in order to effect a lawful arrest. And the apprehension must be one of immediate personal violence. So this includes the threat that there may be some sort of violence at some point, not excluding the immediate future. So the question of immediacy was raised in R. and Constanza 1997, where the defendant harassed the victim over a period of 20 months by sending threatening letters and taking items from her washing, and the victim suffered clinical depression as a result. So the defendant claimed that the letters could not have caused the victim to anticipate an immediate threat, but the Court of Appeal upheld the conviction and found that the victim was caused to apprehend violence at some point, not excluding the immediate future. The courts have also stated that assault and battery can only be committed by a positive act and not by an omission. This was shown by the case of Fagan 1969, where the continuing act theory was created. So the defendant's positive act was driving onto the police officer's foot, and when he failed to move a car, the act was continuing. So this means that when somebody creates a danger and thereby exposes another to a reasonably foreseeable risk of injury which materializes, there is evidential basis for the actus reus of an assault occasioning actual bodily harm, which we will talk about later because that is a Section 47 offence. Now, the idea of liability in such a case has been reinforced in R. and Miller 1983, where a defendant was held liable for arson when he made no effort to prevent or reduce the risk of further damage. So the mens rea of an assault is intentionally or recklessly causing another person to apprehend immediate and unlawful personal violence. And the idea that an assault can be committed by recklessness was established in R. and Venner 1976 when the defendant struggled violently against a police officer and fractured his hand, and he was convicted of assault because of his reckless use of force. Next, on to battery. As the definition of battery is defined in the common law in Collins and Wilcock in 1984, and it says that a person commits battery if he intentionally or recklessly inflicts unlawful force on another person. Battery is simultaneously a statutory offence charged contrary to Section 39 of the Criminal Justice Act 1988. The actus reus of battery differs greatly than that of assault because it requires force to actually be inflicted on the victim, and there is no requirement that the victim apprehends that they are about to be struck. So battery will require some sort of physical contact with the victim, and this can be satisfied even if the victim is unaware of the touching. So the battery requires the actual application of physical force, and the victim does not need to apprehend the violence. And the degree of force required for battery is very slight, and no actual harm to the person is necessary. So in Cole and Turner 1705, Holt stated that the least touching of another in anger was sufficient to constitute battery. So the CPS charging standards say that although any injury that is more than transient or trifling can be classified as actual bodily harm and can thus be subject to a more serious criminal charge, battery will be the most appropriate charge when no injury or only very minor injuries occur. So in determining the appropriate charge, the charging standards state that in determining the seriousness of injury, relevant factors may include, for example, the fact that there has been significant medical intervention or permanent effects have resulted. But as the actus reus of battery is so widely drawn, there are a number of exceptions of the general principle of liability for the least touching of another. So for example, the infliction of force is deemed lawful where a police officer lawfully arrests a person, where a child is subjected to reasonable punishment, and where reasonable self-defense is used. Consent is also usually a defense to battery, and this extends to most of the physical contacts in ordinary life, such as jostling in the underground. So therefore, only touching which goes beyond generally acceptable standards of conduct is subject to punishment. Now, the actus reus of battery may be committed by either direct contact between two people or indirect contact. So the idea of indirect contact may include the defendant's clothes or an object placed somewhere which harms another. Now, this means that the infliction of force may be widely construed, and the defendant does not need to physically touch the body of a victim to result in a battery. So in Haystead and Chief Constable of Derbyshire 2000, the Divisional Court held that the defendant need not have bodily contact with a victim through his body, but it is sufficient that he has direct physical contact with a victim through a medium controlled by their action. So in this case, the defendant punched a woman while she was holding a 12-month-old child, and the woman dropped the child. Other cases of battery include where D sets his dog or another animal on the victim. So the mens rea of battery is intention or recklessness in relation to the infliction of unlawful force on another person, as stated in both Venner 1976, which we looked at before, and Savage and Parmenton 1992, which we will look at in due course. However, for a conviction of battery to result, the defendant must have intended or foreseen the actual infliction of force, not just the victim's apprehension of force. There is also no requirement of hostility in order for battery to occur, as it is simply an intentional touching of another person without the consent of that person. Next, we need to look at assault occasioning actual bodily harm, and this is where we're going to start looking at the Offences Against the Person Act 1861. So assault occasioning actual bodily harm is a statutory offence which is charged contrary to Section 47 of the Offences Against the Person Act 1861. It is an either way offence which carries a maximum sentence of 5 years imprisonment. So Section 47 is satisfied where the defendant commits an assault or battery that causes the victim to suffer actual bodily harm, which I will refer to as ABH from now on. So this offence is an aggravated form of assault, which requires proof that either an assault or battery has taken place. However, this offence is more serious than assault or battery, as it actually requires harm to be caused to the victim. So for the offence of assault occasioning ABH to be proved, it requires both the actus reus and the mens rea of either assault or battery to be proved. And it must then have the added element that the assault or battery occasioned harm amounting to ABH. So most cases will involve a battery that occasions ABH, Yet there can be cases where the defendant causes the victim to apprehend immediate violence, which is assault, and then the victim hurts themselves when attempting to escape. So the defendant will be absolved of liability when the victim's act is not reasonably foreseeable and is a daft act. So this was evaluated in the case of R. and Roberts, 1971, where the defendant made unwanted sexual advances towards the victim when they were travelling in his car. So as a result, she jumped out of a moving car. Now this was held that it was not a daft response, and therefore the defendant was liable for the injuries caused. So this means that the prosecution must prove that the assault or battery did occasion ABH. So the offence of assault occasioning ABH is more serious than assault or battery, as it does require the proof of harm. Now, actual bodily changes is interpreted widely, such that it includes any hurt or injury calculated to interfere with health or comfort, and this was defined in R. and Miller, 1954. In R. and Donovan, 1934, ABH was defined as covering injuries which were more than merely transient and trifling. So the interpretation of ABH is also held to encompass any injury to a person's state of mind, and the Court of Appeal in R. and Chan-Fook, 1993, stated that ABH could include psychiatric injury where properly proved by medical evidence, but it did not include emotions or state of mind. And this was followed in both R. and Ireland and R. and Burstow, 1997. In DPP and Smith, 2006, it was also decided that the cutting of hair without an individual's consent constituted an offence under the Offences Against a Person Act 1861 under Section 47, which is assault occasioning ABH. The charging standards suggest that Section 47 of the Offences Against a Person Act 1861 should be charged where the injuries exceed those that can be suitably reflected as common assault. So in other words, where the injuries are serious. So when determining whether the injuries are serious, relevant factors may include, for example, the fact that there has been significant medical intervention and all permanent effects have resulted. So in terms of the mens rea, it is not necessary to prove any additional mens rea requirement in relation to the actual bodily harm which resulted, and the only mens rea that needs to be proved is that there was an intention or recklessness as to causing the victim to apprehend the immediate violence, or that there is an intention or recklessness as to the infliction of unlawful force. So this was confirmed with R. and Savage, 1992, which overruled the case of R. and Spratt, 1990. So in R. and Spratt, it was confirmed that failure to give thought to the possibility of risk was not sufficient to qualify for a guilt on a Section 47 charge. However, R. and Savage, 1992, overturned this decision and stated that the prosecution is not obliged to prove that the defendant intended or foresaw any ABH in a Section 47 charge, and instead a verdict under Section 47 simply required proof of an assault or battery and ABH to have been caused by the assault. So there was no separate mens rea element to the bodily harm. So the next offence we need to look at is maliciously wounding or inflicting grievous bodily harm. And the offence of unlawfully and maliciously wounding or inflicting GBH is a statutory offence which could be charged under Section 20 of Offences Against a Person Act 1861. Now this offence is an either way offence which carries a maximum sentence of 5 years imprisonment. Now although Section 20 and Section 47 are both punishable with sentences of 5 years imprisonment, Section 20 is regarded in practice as a more serious offence and will often result in higher sentences. So in the case of R. and Wilson, 1983, it was concluded that a jury could find the defendant guilty of occasioning actual bodily harm under Section 47, even when the defendant was charged under Section 20 of the 1861 Act. And this follows Section 3 of the Criminal Appeal Act 1968, which gives the power to substitute conviction of alternative offences. So the actus reus of the offence under Section 20 of the Offences Against a Person Act 1861 is unlawfully wounding or inflicting grievous bodily harm on another person. And this can be committed in two ways. Now this is either by the defendant wounding the victim or by inflicting GBH on the victim. So a wound requires the continuity of the skin to be broken, and there have been cases where the injury has not constituted a wound because there was no break in the continuity of the skin. In R. and Wood and McMahon, 1830, it was agreed that although the victim's collarbone had been broken, there was no break in the continuity in the skin, and hence there was no wound. In C. A. Minor and Eisenhower 1984, it was held that a bruise or internal rupturing of blood vessels is not sufficient to constitute a wound because there was no break in the continuity of the skin once again. So the skin which is broken does not need to be external skin, and a cut to the inside of the mouth or a rupture to the urethra would amount to a wound. To equate this part of the offence with the second part, inflicting grievous bodily harm, section 20 should be reserved for really serious wounds though. Now in R and Burstone 1998, it was also decided that psychiatric injury would be able to constitute GBH. So the charging standards state that GBH means really serious harm, and example injuries would include permanent disability, broken or displaced limbs or bones, and injuries which cause a substantial loss of blood and usually necessitate a transfusion. Next, we need to look a little bit about sexually transmitted diseases, because in the case of R and Deacon 2004, it was deemed that a person could be convicted of inflicting GBH if, knowing that he was suffering from a serious sexual disease, he recklessly transmitted that disease through consensual sexual intercourse to a person who was ignorant of, and therefore unlikely to have consented to, the risk of infection. So this meant that the defendant in this case was charged with 2 counts of inflicting GBH, contrary to section 20 of the Offences Against a Person Act. In the case of R and Konzani 2005, a similar verdict was reached when the defendant had unprotected sexual intercourse with 3 women, knowing that he was HIV positive, and this meant that the defendant was convicted of inflicting GBH contrary to section 20 of the Offences Against a Person Act. Now, once again, the mens rea for this offence include whether an act was committed either recklessly or intentionally. So in the case of R and Moet 1967, Lord Diplock stated that it is quite unnecessary that the accused should have foreseen that the unlawful act might cause physical harm of the gravity described in the section. It is, however, that he should have foreseen that some physical harm to some person, albeit of a minor character, might result. Now in R and Savage 1992, it was declared that to establish an offence under section 20 of the OAPA, the prosecution must prove either that the defendant intended or actually foresaw that his act would cause physical harm to some person, albeit of a minor character. And this was approved by the House of Lords in R and Parmenter 1992, where the defendant in Parmenter caused serious injuries to his 3-month-old baby by handling him roughly. Now, he was convicted of maliciously wounding or inflicting GBH contrary to section 20 of the OAPA 1861. However, this conviction was quashed because the defendant could not have foreseen the harm to the baby, and this meant that it was substituted for a conviction of assault occasioning ABH contrary to section 47. So the final offence is wounding or causing grievous bodily harm with intent. And this offence is unlawfully wounding or causing GBH with intent and is charged under section 18 of the OAPA 1861. So this offence is indictable only and carries a maximum sentence of life imprisonment. So the actus reus of this offence is unlawfully wounding or causing GBH to a person. And these elements are similar to those under section 20 and have the same meaning as they do for that offence. One difference between section 18 and section 20 is that the GBH must be caused in section 18 rather than inflicted in section 20. However, the House of Lords held that the 2 words were interchangeable in R and Burstow 1998. But the difference between the 2 offences comes in the mens rea, as the early part of section 18 mentions the word maliciously, and the latter part of a section requires one of a number of alternative forms of mens rea to take place. There must be an intention to cause grievous bodily harm, and as stated in R and Balfour 1976, mere recklessness is not sufficient for this form of offence. So this means that intention occurs when the defendant understands that GBH was almost certain to occur. Now in R and Taylor 2009, it was decided that section 18 requires an intention to cause GBH and not simply to wound. So this meant that when the defendant stabbed the victim in the back during an altercation without an intention to cause GBH, a conviction of section 18 was substituted with a conviction of section 20. Now, there is also an intention to resist arrest or to prevent the lawful apprehension or detainer of a person. So when a defendant is charged under section 18 for resisting arrest, it should not be sufficient that a mere intention to resist arrest be proved, and instead there must be the requirement of maliciously. So he also foresaw the causing of at least some harm, but not necessarily GBH in this case. This form of offence requires proof of two mens rea elements: an intention to resist arrest or to prevent the lawful apprehension of a person, and recklessness as to whether some harm was caused. So finally, we're just going to look a little bit at consent, as consent is very important when looking at this area of law, as an assault or battery will be rendered lawful by the valid consent of the victim. This means that consent is a defence which negates an actus reus element of the offence. The two issues with consent are what offences can consent be used as a defence, and when is consent deemed to be valid. So the general rule is that consent is only a defence to assault and battery, and it is no defence to any injury amounting to actual bodily harm. So this was proved in R and Donovan 1934, where it was stated that consent cannot render bodily harm legal. So Swift in the Court of Appeal stated it is an unlawful act to beat another person with such a degree of violence that the infliction of bodily harm is a probable consequence, and when such an act is proved, consent is immaterial. So there are some exceptions to the general rule that consent is no defence to ABH or GBH, such as injury sustained during properly conducted sports, lawful chastisement, reasonable surgical interference, and dangerous exhibitions. So these exceptions are governed by policy considerations, namely the public interest. So for example, a qualified medical professional should not be held criminally liable as part of a consensual and legitimate surgical operation, and a sports player should not be held criminally liable for injuring another person if their actions were proportionate to the sport. For example, in R and Barnes 2004, it was deemed that Barnes could not be held criminally liable for breaking the leg of a victim. Consent is also available as a defence where injuries amounting to ABH or GBH are sustained during rough horseplay. So there is a big case on this, and this is R and Brown 1994. And the case of Brown includes a group of sadomasochistic homosexual men who willingly participated in committing acts of violence against each other. So their acts of violence took place in private and with the consent of everybody involved. So they sustained injuries which amounted to ABH and GBH. However, they were then charged with offences under Section 47 and Section 20 of the OAPA 1861. So the House of Lords upheld their conviction with a majority of 3-2, and they agreed that consent is no defence to ABH or GBH where such injuries have been inflicted in the course of sadomasochistic activities. However, in the case of R and Wilson 1997, it was agreed that the consent was sufficiently different to R and Brown 1994 because the case involved no aggression or sadomasochistic element, and the branding was carried out as a result of consensual activity between husband and wife in the privacy of the matrimonial home. So finally, we just need to consider when consent is actually valid. Consent is only valid if it is freely given by a fully informed and competent adult. So this means that consent obtained by a minor is invalid, and in the case of Burrell and Harman 1967, it was held that two boys aged 12 and 13 were incapable of giving consent to having a tattoo. Consent is also invalid if it is obtained by fraud as to either the identity of the defendant or fraud as to the nature and quality of the act. So thank you for watching this video, and see you soon. Bye.